thanks guys for coming and joining us today. When Tim had mentioned this group and some questions that you had, my mind immediately went to the number of kind of panicked probates that we've done, where there's a closing set, and guess what? It doesn't turn out that the people who we thought owned it, and what do we do about that? So we'll address some of that stuff today. Already has been introduced a couple members of our team. Tony does estate planning and probate. Meg, our client services director. I've moved into a role of supervising the estate plans that we do. We've got two other attorneys besides me that does estate planning, but I probably know the answer to your question. If I don't, it might not be the answer you want, but I have answers, and if we don't have an answer to your question, I would love to get your contact information. We will absolutely follow up with you if there's anything that you would like to know. Also, I'm just going to leave these up here, but we've got some information on a little bit about our process. I'll put that here. And we've got our handout we give to folks about wills versus trusts. And we'll talk about the difference and why you might care about those. Okay, so Stonehenge has been around for about 8-9 years. We work with families, we do family estate planning, and we get a lot of questions. And we get a lot of questions about real estate ownership. We've had more than once where prior to the pandemic, where someone has passed away, they thought it was owned as joint tenants with right of survivorship. I'll cover some terms here momentarily. Turns out it's tenants in common. They just took title the wrong way. And now we have a deceased person on title, and what are we supposed to do? It's probably going to be probate, unfortunately. And the days where I could get that done with Hennepin County in I've done it in 3 weeks before, and that's gone. That is totally gone. We are not even finding a hearing or a call with the registrar for 2 to 3 months. So if you have a pending sale and there has to be a probate, very good chance it's going to, if it doesn't screw up your deal, it's going to require some conversations and some finessing along the way. I confess a little bit of ignorance. I don't know what information is available to you about the type of ownership that a property may have prior to you getting close to closing. If you have access to a friend who's at a title company, I think you could save yourself a lot of trouble, but I don't know that that's really your job. Your job is to be a title company.
I would say the opposite. Our job is to be proactive and reach out to the title company if you think.
I would love it. I think that would save yourself a lot of trouble if you're able to do that. So here's the things that we run into when it comes to, well, I'll back up. One thing that we do is we have found that there's certain title companies that'll charge you $25 and they do an ownership report. It's a little bit different than an ownership and encumbrances report, which talks all about the mortgages and everything else. Those are a few $100s. $25, we found a company called Land Title. Use your company, use whoever it is that you like, but they'll pull the deed for you, and they'll even give you a little summary on how things are owned. And sometimes there are surprises in the planning process because we need to deed stuff into the trust. We need to transfer some ownership, and we'll find that things aren't the way we thought they were going to be, or the way the client thought they were going to be. Things that we're hoping for usually, if someone has passed away, is that, and I'm going to again say ignorance on how well you know these terms. I'm going to cover some things which might be very, very common sense to you, but I just want to get us on the same page. When it comes to a married couple, for example, joint tenants with right of survivorship, that's what we're looking for. If you see a deed, it's going to say Philip and Mary Roos, I'd say we're married as joint tenants, the magic words. If those terms are not on the deed itself, it is not joint tenants, it is something else. And in Minnesota, the default is tenants in common. With estate planning, for married couples, we like the joint tenants thing because if someone has passed away, it just goes to the surviving owner by filing an affidavit. Super easy. We charge, you could do this on your own. We do it with a nice letter and make it, kind of guarantee it, for $300. But that's it. You get that other owner off. You got the sole owner now. Good stuff. Things are clean, ready to sell. Very easy to do. You can do that at closing. That's something, if it's joint tenants with right of survivorship, that's something that can be done anytime. So that's fantastic. It's less cool when it's a family cabin and siblings own it. we're less likely to like it there. And the reason is, if I got kids and my brother has kids and we have our family cabin up north and I die, well, now it's his cabin. So my kids are cut out. That automatic transfer can be very good. It can also be unfortunate depending on the family situation. So you might see things like family cabins where it is absolutely tenants in common and it's that way intentionally. When it comes to the family home, it was probably an accident. You see that. They meant to take it joint tenants and someone just didn't do the deed correctly, prepare the deed properly. So here's things we've seen. We've seen married couples who thought they took as joint tenants, but it's tenants in common. We've seen married couples where one person bought the home, got married, the other person moved in, and they just never got on title. And then the person who is in title has passed away, and of course it doesn't transfer to the spouse. It's just one of the more challenging ones I've run into is a contract for deed, which, you know, when you pay that contract off, someone's got to actually file the deed, right? I mean, contract for deed. And it was in the 70s, and they paid off the contract and gave them the warranty deed, and then they just stuck that in a file somewhere. They didn't realize there was supposed to be a step 2, and now it's been 20 years and it's gone. And then they've died, and now they need to sell it. And of course, we don't. Not only are the owners gone, so they can't do a real estate deed, but the people who sold it to them are gone because it was from like 30 years ago. That was a quiet title action. That was a big deal. That took months and months and months to get that done. If you see something that is owned by a trust, that's probably good, because that probably means that it can be transferred out or sold without the courts involved, which means it can just kind of get done. And that's a positive. So with that in mind, has anybody had to go through a probate either with a family? I don't want to pick on you, but if a family member or just a client where you've had this happen, where it's been like,
Literally just got probate docs from my aunt in the mail.
okay, all right.
It's a little complicated because she didn't live in this country.
Oh, wow.
And they're asking me to do a bunch of things that.
Not in this country. Did you have property in the U.S.?
No, she's an English citizen, British citizen.
British citizen, but you're appointed overseas?
I'm named in the will.
You're named in the will. Got it. So you probably got a copy of the will and maybe.
Yep.
Right. Good. So probate is an administrative court proceeding, and the purpose of this probate process, this court proceeding, is to protect the rights of all the people involved in the probate. So that is all the people who would get something by statute. Maybe we've overwritten that statute by using a will. I'll talk about that in a moment. So now we got to notify anybody who's in the will and anybody who would have taken in the statute, even if they're not taking it. Still got to tell them, got to take notice there, give them notice. And then all the creditors of an estate. So we've got all the little credit card companies, the medical bills, Uncle Joe who lent, $1,000 and never got his money back. We got to publicly give notice of this. And through this public process, we give people the right to say, you know what, I see they have a will, but they did not know what they were doing when they signed that will. They probably didn't know to do that. Or someone was under duress and being influenced by somebody. And of course, the creditors have a right to their money, and there's an order in which these people get paid, and we can establish that all through the probate process. So probate has a very positive purpose. And if there's no rush to it, it can be very useful. It can also head off disputes if two people are arguing. But we're going to be in front of a judge anyway, so we're kind of already there. So probate has some positive things. The problem with this process of transferring assets by probate is, first off, it takes, especially for you guys, it takes a long time. Even the easy probates right now, like I said, are a few months out. You can oftentimes get the house taken care of at least somewhat quickly, but the residual stuff that has to be taken care of, it can take at least a year, if not a couple of years, go from start to finish. There are ways to avoid probate if there's advanced planning, but you're seeing this probably after the fact. It's a little bit too late for that. Probate can be expensive. It's not the end of the world. People talk about how awful probate is and how expensive probate is. Certain states in the U.S., California, Florida, New York, horrible. It is $50,000 to get through it. Minnesota, it's just an hourly thing. We find them coming in $3,000 to $10,000. So somewhere in there, depending on how many moving parts there are. It's not cheap, but it's not this like 50, 60, $100,000 thing. So it's a little more palatable from that perspective. Again, a lot of that can be avoided by getting ahead of this. Again, by the time that you guys are sometimes seeing this, we're past the point of that plan. So before I go any further with kind of the things to watch out for, and again, my primary things are if you can get a hold of an ownership report and take a look at who owns it. Like, is it the people you think own it? Is it a total stranger? Like you didn't even know this person was a party to it. It's possible there's a contract for deed or some other agreement and it never got completed. I've had the title company be wrong before. That's happened just because they tell it to you. You know, you double check, panic. Oh my gosh, that's not what I thought was happening. They should be able to tell you if it's joint tenants or tenants in common. Here's a little quick tip I discovered. There's some real estate deeds from the 80s that up in the upper left-hand corner of this thing, in little tiny words, it says deed from individuals to individuals as joint tenants. That's the only place it appears in the whole thing. So when you look at the real estate deed, it'll just say from Joe and Jean to Mike and Marcia, and then it's silent. You're like, oh my gosh, tenants in common, panic, let's go. And then no, it actually works. But yeah, it's terrible, terrible. But now things are hopefully a little bit more clear there. If you can get ahead of that and get an answer to that sooner than later, you're going to make things easier on everybody. And however it is that you do that, again, title company or whatever, it's that surprise at the end where we almost can't do anything. We just have. You're going to have to talk to your clients about this process. So, any questions on that? Yeah.
Out of curiosity, why is it so much more expensive elsewhere?
There are some states that have, the question is, if anyone's listening on Zoom here, the question is, why are some states so expensive? There are some states that have statutory probate fees. So they're going to say the attorney gets 1% and the executor, whoever gets assigned as PR, gets 1% or something of that nature. And they do that because they want people to want this job because the job is hard. So how do you get someone to take this and make it worth their time? They believe that you do these statutory fees. So you can get, give $1 million of probatable assets, 20,000 plus expenses that just right there. And then some states are higher. Actually, I think California might be as high as 3%. And that's why. It's oftentimes the statutory fees. If you go to Wisconsin, Wisconsin is more expensive than Minnesota, not hugely, but they actually have a filing fee. We have a straight up filing fee of $300 and some dollars. Like if you want to open up probate, $300 to the court, reasonable. If you go to Wisconsin, it's based on the size of the estate. So the filing fee could be $4,000 or $5,000 in Wisconsin. So every state's different. And actually, you're bringing up a really good point. The probate statutes, the statutes that control this process, these are state statutes. They're not federal things. So there's some tax laws, like state taxes and stuff that are federal. These are state by state. So every state's going to be different. So some of the things I'm telling you today, if you're working on a Wisconsin property, you may find that things are a little different than what I'm talking about, but I think it holds true pretty well. We are licensed in, we're all in Minnesota. Tony has a Wisconsin license, although we haven't done much with Wisconsin at this point. Rory is in California, which is a really hard place to get a law license, so we are trying to maintain that for him, and then South Dakota. So those are the states where we have a presence, but primarily Minnesota. I mean, really.
So you do have agents who are licensed also in Wisconsin.
Okay. It's, I would say, depending on what the probate was, sometimes we would just advise people to get local counsel, just easier if they're in Wisconsin to work with someone closer. But if you have questions about any of this stuff, again, take your information.
Can I just reiterate what you said earlier? So if we have clients, somebody has passed away, our guidance to them is you have to go through probate first, which could take 2 months or it could take a year to 2 years.
I would say if once you confirm ownership and you're like, yep, looks like they're going to need probate to transfer this. Once that's there, you would say contact a probate attorney us or one that you prefer, it could be the other company already that you use. And you can just kind of tell the clients, you know, you got to get started on this because them. They're the ones that are going to have to do it. You can say fair warning. It'll not years. It will. I could envision a situation where everything goes wrong and it takes a really long time. By and large, I'm finding that we can get the house distributed in 3 months.
Like it could go on the market as quickly as 3 months.
You could list it probably right away. You just can't do anything.
The closing, cheaper closing about 3 months after. So you could list it, get the signed purchase agreement, do title work, and then just have the closing scheduled out, done,
Float.
you get the letters or something.
Always a little bit of a risk if things go completely awry with that
That
probate.
makes me a little uncomfortable.
Yeah.
Whatever. I just wanted a general, like, what to advise clients. The ones I've had have been very quick. They went through probate in a couple months and we had it on the market.
That's good. It's Hennepin County used to be extremely fast. There's different levels of probate. There's an informal probate, which is all by mail. Nothing's wrong. It's super easy. There's 1 or 2 kids. And that's the one where we can, it's by electronic filing now, but you electronic file everything. You don't even talk to a judge. You talk to the county registrar, the attorney does, and they're like, yep, looks good. We'll get you guys letters and letters testamentary. That's the thing where you can actually be authorized to sell. There is a 30-day wait period on real estate after that.
You need formal, yeah. If it's formal, it's immediately after the hearing, as soon as the court processes.
And then you're good to go. But that was Hennepin County is where I was able to get it because I knew the registrars, I could get it done in 3 weeks. And it would be scary, but you could do it. And now that's just gone. 2 months, that I could see that sometimes. I would just tell them, be conservative. You know, tell them,
What is it that makes the delays longer now?
court capacity. It's court capacity. Everything was shut down for some time, and now they're getting back. It's just everything's backlogged. Yeah, that's really the reason.
So on piggyback on what Aaron said, the house or the property might be one portion of the probate. And so even though the probate could take months and months and months, usually you could dispose of this portion of the probate, i.e. the real estate, within 2 to 3 months.
Absolutely.
So you don't have to wait for the whole probate thing to be complete before you can dispose of the house.
That's generally the case, right?
Okay. And then a question I had is if a married couple or an engaged couple is purchasing a home and only one person is on mortgage, a lot of times only one person goes on to title. But is there a good way for them to seek out how to go into title together at the time of closing?
Sure.
And is that something that they need an attorney for? Can a title company do that for them? What do you see there?
The question, I'm not sure how well Zoom picks it up, so I'll make sure I get the question right too, is if there's an unmarried couple, but they might become married or not even, just an unmarried couple generally, I guess. Oftentimes they don't both have to go on the mortgage. It's just with one person can qualify by themselves. Maybe they want to do that. That also means they can go into title by themselves too. Is there a reason for them to maybe both go in title? That yes, the title company can totally do that. They can take title however they want, even if one person's on the mortgage. The counter to that, and I always want to be very careful, is if they don't end up getting married now, you know, even though one person maybe put the down payment on, when you make a joint owner, you absent another agreement, absent a cohabitation agreement or something that they've created. If I have a $200,000 down payment that I'm making I put down on a house and I add someone, I've just given them $100,000, literally. So if we sell, hopefully they're cool and they'll just, you know, but they don't have to be. So there's some scary stuff there. And on every house payment that gets made, in theory, because they're jointly owned, that's joint equity. So there's some caveats to that. But if the question is just, you got to be married to take joint? Absolutely not. They can take it however they want to take it. Yeah, and you know, what's right there? When it comes to estate planning, we like joint ownership, but there's a reason there's tenants in common. I'll mention this. When it comes to tenants in common, so if I have joint tenants with right of survivorship, I die, survivor gets it, whatever, it's their house now. When they die, it's their estate plan that's going to decide where things go. So in the case of the cabin up north and my brother and whatever else, well, whatever his will says or whatever he has, that's where that stuff's going to go, whether I like it or not. Tenants in common can be beneficial there because your 50%, your undivided 50%, goes according to your estate plan. It might go in two completely divergent directions. But if I want my 50% to go to my kids, and if something has happened to one of my kids, it goes to their kids or goes to their spouse or whatever I want, I can do that. That 50% is parsed out and it does whatever I want it to do. There are times when we like that, do that intentionally, but married couples is usually not one of them. It's usually
Joint, is it always 50/50?
absent another agreement, joint tenancy is deemed to be 50. You can do, you'll see it sometimes, it'll say an undivided 25% belongs to Joe and undivided 75% belongs to Mark. And as joint tenants. So if one person dies, the other person just gets whatever that percentage is. I've seen that. I've seen really complex things. I bet you guys have too, where there's a hunting shack or something and it's like 12 owners. And these three people own it jointly because I can have my half jointly. I can be Philip and Mary Roos, undivided 50% jointly. And then, whoever the other couple is, they own theirs jointly. So their share will go back and forth if one dies. This share will go back and forth if one dies. But if we're both gone, this is tenants in common and it follows our estate plan. So you can do that too. Yeah. I don't like that. I don't like estate planning on deeds. I think that deeds should go someplace and then there should be an editable document that you can make, that you can update. That'll see where things go. But you see it. Good question. Other questions? I'll talk about some tools that we use to control this stuff. But anything you guys are wondering about?
I have a question. What if there is a married or unmarried couple and one person is on the deed and you want to add another person? Do you need an attorney to do that, or how do you go about adding a person?
Yeah, I don't know that you need an attorney specifically. A title company can do this. But
Okay.
what they're going to do, so if I own a house, you'll see this deed sometimes. If I own a house in my name only and I want to get my wife on there, it'll say, okay, I'll back up here one second. Married couples, spouses have some special rights to real estate. I can't disinherit my wife completely from the estate plan. She's guaranteed a certain share. At the minimum, she gets a life estate in the house and some other things. Okay, but if I want her to release that, I need her name on the deed when I sell. So you'll hear about this, that married couples have to both sign a deed when they sell. That's the reason you got to release these spousal rights. Okay, so I own it by myself, but I'm married to Mary here, and I want to get us both on the title. So what you're going to see, Philip Roos, owner, and Mary Roos, married, hereby quit claim to Philip and Mary Roos as joint owners. Right? So I'm quit claiming, or whatever it is, however I'm meeting it, to myself, but I'm going from 100% owner to 50% joint owner. Yeah, so it's just a deed. Title companies can do it. We do that somewhat regularly. That's a good question. Anything else? So we've got this probate process in front of us. And if you don't have, now let's say this more for personal use as you're going off into your own lives, but this affects your clients as well. There's a couple ways to control. You guys have anything to add? Questions? Okay. Am I doing okay? Good so far? Okay. I'll hear about it later. The way that we determine who gets what by default is this probate process. And if there's no will documents, no wills.
I have a question in
Oh,
that.
how do I add children to a deed before I pass away? Okay, there's a number of tools available for this. What I don't typically recommend is adding kids to your house while you're alive. There's a few reasons for that. You can do it. If I make my kids joint owners, I die, it goes to the joint owners. We just avoided probate and they get the house. That sounds on its surface like a very positive thing. Number one, I'll say this broadly, never put minors on real estate. That is a conservatorship. It's a disaster. You never want to have minors getting a hold of property. they can't sign contracts. So they're completely out of luck there. Don't do that. That's another red flag. If you happen to notice there's little kids on the deed for some reason, that's going to be a problem. It's solvable, but it's a big deal. Okay. So it's certainly legal. Say I got these couple adult kids. It's certainly legal for me to say, Philip Roos, married Mary Roos, hereby conveys quit claims to Evelyn and Magnolia as tenants in common or whatever it is, or I quit claim to all four of us. I can do that. That's perfectly legal to do. Things to watch out for with this. Number one, that's a gift. So it's probably not a big enough gift to trigger gift tax, but it is for tax purposes a gift of 50% of whatever I own in the home. I won't get into this too deeply, but there's a $15,000, 16 now per person annual gift exclusion. You can give $16,000 per year per person. Every single year you want to, you can do that. Give it to strangers, give it to family, doesn't matter. And then you can do it next year and you don't got to tell anybody about it. $16,001, you're supposed to file a gift tax return with the feds, Form 709. You're not going to owe any tax because there's this whole lifetime exemption on top of that, so it's probably not a big deal if you don't, but that's the rule. So gifting more than $16,000, gift tax return, and by adding a joint owner, you've done that. You've probably gifted at least $16,000. Secondly, if I live in my house, there are some homestead protections from bankruptcies. If I'm being sued, they can't take my house because there's these homestead protections. Also, if I sell a house where I live, and you know this rule, I've been there 2 of the past 5 years. The past 5 years, no cap gains. What I've just done is I've taken half or whatever percentage of my house and I've removed those protections. So now this half belongs to my kids. They are not homesteaded here. This is a rental property. So if they get in trouble, I may lose my house. I've exposed myself to their liability. Also, when I sell, only the 50% that's mine gets that capital gains exclusion. Any gains that they have is going to be gains that they're supposed to pay. Whether people know that enough to actually do it, I don't know, but that's the rule. And speaking of capital gains, the capital gains that when there's a lifetime gift, so let's just use a basic example here. Let's say I buy a share of stock for $1 and it's not worth $100 and I give it to Tony. That lifetime transfer is going to carry with it that cost basis. So it's as if he bought it for $1. So if he wants to sell it, he's going to pay gains on $99, $99 in capital gains there. That's for lifetime transfers. And that would also apply to the house. So if I'm one of those people that bought a house in the 70s for 30 grand and now it's worth $600,000, well, I've just given my cost basis to my kids. When they sell it, life or death, they're getting those gains. If you gift something to someone after death, though, or at death, capital gains go away. It costs a step up. So I bought that stock for $1, willed it to Tony, or gave it to him with a pay on death beneficiary designation on my account or whatever it is. Now it's worth $100. It's as if he bought it for $100. So he can turn around and sell it and it's gone. So that's a long answer to that question. If you wanted to do that, you just do a real estate deed. You can add your kids to your property with a real estate deed, whether it's advisable or not. Our office typically says no. There's another thing you can do called a transfer on death deed, and this is an actual real estate deed that is filed with the county now. And what it says: Philip and Mary Roos convey and quit claim to Evelyn and Magnolia, but not effective until the death of the last of the grantor owners to die. So when the second of us dies, it will transfer to the kids automatically, probate free. More caveats are talking to a lawyer. So let's talk about when that's appropriate. You're giving someone an illiquid asset. It can't be divided up. It's not like cash where they can kind of go their own way. They're stuck with this thing for a little while. So we need to make sure there's liquidity for these kids. Do they have enough money to keep it up while it's being sold or whatever? Do they get along? Spouse has got to sign. So we got 4 signatures we got to track down in my example. We will do transfer and death deeds for families when they have 1 responsible adult child in a good marriage. Sometimes you can persuade us 2 kids. Once you get 3 kids, it's the wrong tool. We don't give it to 3 kids. We've had people ask, like, I got 6 grandkids, I want to give it to them. It's like, oh my God, 12 signatures. No, go to probate. Go to probate. It's going to end up there anyway. So just don't do that. Okay, so that's the way you could convey stuff and reasons to do it and not do it. The nice thing about the transfer and death deed is it does get that step up. You're not giving anything away until death. There's no liability. I haven't given my house away. It's still mine. The second death, cost basis goes away, transfers to 1 or 2 people, probate free. It's very easy if it's the right tool. Okay. Hopefully I killed that one.
I
but
think you
that's-
answered the question.
Yes.
Okay, I think so. All right. All right. So if I have no planning in place at all, nothing at all, there are default rules that are going to decide where the stuff goes. And these are the intestacy statutes, default rules that every state has. Minnesota has them. And it's built out in different situations. You've got, if you're married and don't have kids, this happens. If you're married and have kids together, this happens. If you're married and you have a child from a previous relationship and this person has a child and then you have a child together, here's what it spells a lot of this out. And this is just kind of what's going to happen. We don't typically like the default rules. You also don't get to choose who's in charge. There's the executor or the personal representative. That's going to be spelled out for you as well. We want to overwrite those rules. We don't really want the default rules. That's what a will is. A will is a court document that we give to probate. It goes through probate. That's important. Wills go through probate. They're public court documents. I've heard people say, if I have a will, why do I need to go through probate? It says wherever it goes. Because all it does is telling the judge what to do. And it's saying, here's who you're going to appoint. Here's the order we're going to pay the bills. Once we have that, here's who gets it. If something happens there, here's who gets it. If this person doesn't want to be in charge, name this person and not that person. They can do all these contingencies and create your own rules. And we like wills because they control probate, but they go through probate. So if you're talking to one of your clients, they're like, yeah, it's in mom's name, but we have a will. It just goes to us anyway. Cool, good. But we're still going through probate. That does not avoid the process. So option 1, do nothing. We've got the statutes. Option 2, do a will and overwrite those statutes with your court document. It is a court document. It's public, so anything you want to put in there, any opinions of your relatives, it's all going to be out there. Public stuff. I have some of these lifestyle shows you see, like Minnesota Live on KSTV. They need filler, and I'm good filler, so I've been on KSTV a couple times, and we've talked about passwords and how to plan for your digital assets. And I've had people like want to put that in the will. It's like, not put your Bitcoin key pass in your will. It's going to be like, that's everybody's information now. All right. What if we wanted to avoid probate and the transfer and death deed wasn't the appropriate? I got 3 kids, so I can't, it's wrong. It's transfer and death deed is not the right tool. Also, I want some contingencies built in there. That transfer and death deed, I can kind of just give it to my adult kids. I can't really do like, and we don't really want to do estate planning on. I want to say to my kids, if something happens to one of my kids, it goes to their kids, but only if they're 18 years old. If they're under 18 years old, it's got to go somewhere else because we don't want to conservatorship. You don't want to do any of that stuff. If you want these backups and everything else, you do number 1, embrace probate. Do it on the will. Say where all the backups are. Go to court. Let it handle it there. That's okay. People go to probate all the time. It's not an evil thing. It's hard when there's a rush, but it's not the end of the world. Probate. But the alternative to this, and the one you hear about a lot, is called a revocable trust or a living trust or a revocable living trust. All the same thing. And here's how I describe these to clients. So we've got the will, and we're bracing probate for something. This is what we're doing. We are purposely, by virtue of not doing anything else, directing our stuff to the probate court system. What we want to do here is we want to purposely direct it away from the court system to something else. The way we do that is we want to get this under a private. So you guys sign private agreements all the time. Contracts, leases, mortgages, credit card agreements. You don't need a judge to use your credit card because these things are under private agreements. You don't need the court to help you with this. You just get to do it. So what if we could take all this stuff and put it under a private agreement? And that's what this revocable trust thing does. Think of this thing. We talk about this so many times. Think of this thing. I like to think of this thing as being like an open Ziploc bag. So while I'm alive, I got this open thing, okay, trust. and I can take my stuff, my house, and I can put it in the bag. Put it in the bag. RV, put it in the bag. Change my mind about RVs, sell it, no problem. Cash, whatever. I can also direct stuff into the bag after death. So I could do a transfer on death deed into the trust. I could go to my life insurance and be able to fill in the very rich trust. Bag. In fact, that's what I do. I can change my mind anytime I want to. Pull it right back out. I still own it. Still mine. Open thing. I can change this document just like a will anytime. It would be amendable. If it's revocable, meaning you can rip it up anytime you want to. It's permanent as you want it to be. But the thing is, anything that ends up, you can also almost picture a funnel going into this. Anything that pours down this funnel and ends up in the bag is going to be controlled by our private family agreement, our trust agreement. So picture when I, during life, amendable, whatever, I could put stuff in case of at death. In my case, I have a joint revocable trust. So the second of us that died, my wife and I. Now this thing is going to zip shut. Now, irrevocable trust. Irrevocable trusts are just that. They cannot be revoked, they can't be amended, you can't change the terms, and it lays out everything. It basically says what my will says. It says, here's who's in charge. If this person can't do it, this. Everything goes to Mary. If not her, our kids. If not one of them, their kids or whatever I want to write it there. I can say, hang on to the money until they're 25. There's not going to use that money to pay for college. I can do whatever I want to do. And anything that ends up in this thing, including the house, will do whatever I say it's going to do. And it's going to do it with this private family agreement. Because of that, we don't have to go to court. So in theory, if there's a house in here, we could list it the next day, really. There's still some notice about like medical assistance, stuff like that, that you're going to have to do before you transfer, but you don't have to go through probate very fast. The only thing that has to happen is when it comes time to sell this house that is in the trust. So if you notice that you have a home in the trust, they want to get a jump on this. The trustee, whoever it is, that's the manager, the CEO of this thing, we need to get a affidavit of trustee. That's them from a notary saying, I'm the trustee. It's just like letters testamentary in a court system, but it's just done by a lawyer. It's a one pager, maybe a two pager. And then we need this thing called a certificate of trust, also a 1 or 2 pager. And this is something that spells out all the titling information really for the trust. And those are really the 2 documents we go for. I guess sometimes there could be some other property they have that they need help with, but that's it. And you can get that done anytime. So if it happens to be in a revocable trust, we solve that probate problem altogether. And that is a very popular tool. I would say most people that contact us think they want a will until they realize what a will does versus a trust, and they end up revocable trust. Meg has gotten very good at explaining to folks kind of what the difference is between these two, because most folks don't know what a revocable trust is. Why would they? No one talks about it. If Prince had a revocable trust,
Oh, boy.
it would have been a lot easier.
Oh, good example.
So if you have a trust and it's revocable, you're alive, you're the trustee because you own it.
Yes.
And then once you and your spouse or whoever is on the revocable trust are dead, it becomes irrevocable. And have you named a trustee for that irrevocable trust?
Yes, you name a successor trustee,
Okay,
which is the equivalent of an executor,
okay.
but for a trust.
And
So
that person needs the certificate of whatever you just said.
that
If
person,
you're
yes.
selling your own, you don't need a certificate of something because you are the trustee of your own, or do you still need it?
You'll if it's in the trust, you will still need the title company and the county will still need a certificate of trust and an affidavit. We give the certificate of trust
When
to
you
people
create it.
when they create it,
Yes,
we'll have it.
fair, okay.
But sometimes they want this other thing called an affidavit of trustee, just saying, yes, you're still the trustee. A few $100. Unfortunately, we tend to get requests for that at closing last minute. So that's a big rush. But that's yeah. What we try to do for folks, if we're doing a joint trust, so one trust for a married couple, there's a couple reasons we can't do that. But if we can do it, we like to do a transfer on death deed into the trust. That's what I have for my family. So when Mary and I are gone, it will then transfer into the trust and we're good to go. Because if we sell it, we don't have to deal with any of that. It's you can sell it. If you want to take out a HELOC, no one has to know. It's still in my name. Sometimes when things are in trusts, they want more information and it's more cumbersome during life, really. But we come upon trust from other attorneys a lot where stuff is actually in the entity itself. And then, yes, we need, the county's going to require proof that this is named properly, that the person signing really is authorized to sign, and that's where we get the money.
And if I think sometimes there's a confusion, if a trustee is named and that trustee is married, that spouse really has nothing to do with the trust documents, or does that spouse have?
That's right. So by that example, if I give my house to my 4 adult children, if I did it on transfer and death deed, how everyone's got to sign. If we put it in the trust, just the trustee has to sign to sell. That's it. And their spouse is out of it, unless I name the spouse. And then they liquidate it and they just give the 4 kids the money. And easy. Good question.
Is there any transfer of trust prior to death, or would it always be kind of a death thing?
Yes, you can absolutely put the property in the trust first if you want to. When someone is, for example, elderly, or if we need to equalize assets between people, or if they have a prenuptial agreement and we don't want to make it into a joint thing, if there's like a separate trust situation especially, you can do a quick claim deed. Philip and Mary Roos convey a quick claim to the Philip Roos Trust. Boom, and now it's actually in the entity now. So you can do it before death if you want to. If there's no compelling reason to do that, we have just found it's easier to live your life owning your house as a person. But if clients wanted to do that or had a preference to just do it, for sure. It's just that if you want to refinance or take out a HELOC or sell, you just got a couple extra documents, and sometimes people find that frustrating. So we just try to accommodate that.
I want to touch on the cost differences of will versus trust, because I was pleasantly surprised.
I'm glad you were. Sometimes people are unpleasantly surprised. The thing about a will is just a court document that's used someday. So there isn't really anything else we have to do besides get that thing written and executed. We are focused on getting this done properly. There's at least an hour-long client meeting. There is a signing with the attorney. There is a phone call with the attorney. The attorney's designing the thing. So it's a few hours of work no matter what we do. So if you're doing, and this is different everywhere, but if you're doing a will plan, so a probate controlling plan, and we always do healthcare directives and powers of attorney for free. I should have you talk about this. You talk about this. I get this wrong. Healthcare directive allows someone to make healthcare decisions for you after you're incapacitated but not dead. And a power of attorney allows someone to make financial decisions for you if you are incapacitated, not dead. And we want to make sure. Single person, probably $1,200. Married couple, probably $750 each, or about $1,500 total for the whole thing. If people are looking to avoid probate and create revocable trust, well, now we've got the real estate deed, got to get some instructions, a little bit of sort of the assets, because we've got to make sure. We've also found that there's a lot more questions. The meetings take a little longer. What you're going to find is for a single person, all in. It depends what they have. I don't want to say all in. If you got 12 different pieces of real estate, it's going to be different. But for the average family that has a house, revocable trust for a single person, probably $2,500. Joint revocable trust, that's what I have. Married couple, $3,000. And sometimes you can't do a joint trust. You have to do separate trusts. You can't combine stuff. There's a prenup. We have 2 different plans. I want my stuff to go to my kids. She wants her stuff to go to her kids. We don't want to combine them. Sometimes there's estate taxes, death taxes, and we have to equalize assets. We can't keep them separate. So you're going to see this with wealthier folks. But we get 2 whole separate trusts, one for Phil, one for Mary, and that's probably $4,500. Other real estate deeds kind of add into that, and you can change it a little, and sometimes some complex things come into play, but that's what.
Is there any type of power of attorney that lasts after death?
Yes. No, there isn't. Power of attorney stops.
End of death.
But sometimes people use the revocable trust. So the question is, can a power of attorney last past death? Power of attorney by definition will end at death, and the executor or whatever the estate plan will take over. But
What if there's no executive?
if there's no executor or no personal representative appointed, well, if it's real estate, we have to appoint someone. So we'll go to the statutes and see who's in line. Start trying to find someone. A revocable trust can be used for incapacity for any assets that are in the revocable trust. So if I do take my house, take my name off my house, put it in the trust now, put it in the, not transfer on death deed, put it in there right now. Well, if Mary and I are both incapacitated, my successor trustee, even though I'm not dead, can act as long as they are truly empowered to do so. So they could sell the house during incapacity, just like a power of attorney could. So that could act in incapacity, and then adding incapacity, you have to state the person.
I think there's a question.
That's some very good questions.
Bill, and while she's pulling that up, I just wanted to, I know you brought it up earlier in the session, but on the back end of the costs, when you've got the will, you've got probate, which you said was, what was the kind of a range?
Right. So by going the revocable trust route, you first off make administration happen very quickly. So I think that's where the value is myself, is just the peace of mind of knowing that this is going to be easy. That's why I like them. It's less about cost, it's more about like, I got little kids, I need things liquidated, I don't want this to take 2 years, I just want it done. So that's why I find value in that. But you also avoid probate. So what's probate, 3, 4, 5, 10 grand? Well, you don't have that anymore. You skip that. Also, a will is a court document. Don't ever forget that. We don't really want to submit 20-year-old court documents if we can help it. We usually want to rewrite our will. Rule of thumb, take my advice or don't, but rewrite that will every 10 years. New court documents, start over. Everything in your life has changed, believe it or not. Laws have changed, just fresh document. Revocable trusts, because they don't go to court, we don't have to worry about the best practices quite as much. So they stay a little tighter, a little longer. You might still have things that need to be amended because your life has changed, but the documents themselves don't get quite as stale as quickly. We usually say every 20 years for revocable trust. So there's some savings. There's some savings on the back end for sure. For me, the value has always been, it's just, I feel comfortable knowing that, peaceful for me to know that this is just going to get done. I'm also a private person, so if I can keep my stuff, my neighbors don't care. They know everything, but I still like the idea that they.
We have 3 questions in the chat. I can read it.
Yeah, you want to read it into the record? I suppose everybody can see it.
When a homeowner passes away and only their kids are remaining and the home is not in a trust, what would the survivors need to do to be able to sign the listing agreement and put the home on the market?
The first thing we got to determine in that situation is we have to make sure that they actually would get the property. So that's one thing that could be problematic. Sometimes kids think they're getting it, but if there's a will out there, maybe it doesn't give everything to the kids. Maybe it incorporates the grandkids, maybe there's charities, maybe there's other things. If we are positive that the kids are going to get it, then they could probably list it right away. It's just, they can sign the listing agreement anytime. But again, our problem is going to be with the actual closing, because you can't do that until they own it. So we got to get it out. We got to get that probate started and rolling.
So there's something, you would have to put that in the purchase, right? There's got to be some kind of an amendment.
Contingency or
goes in there.
something.
Yes.
Yes, okay. We don't need to talk about wording, but
Yeah. Yes, yes, that should be in the purchase. So the answer, the question is just, what has to happen for the kid to sign it? They can sign it. Make sure that they are legally able to, that that's actually in the house. But assuming it is, they can sign it, right? They can sign the listing agreement. They just aren't going to be able to close until we got the process.
The next question is, if I'm under contract with held for market with power of attorney and the parents died, does that make my contract void?
So the power of attorney sign the contract on behalf of the parents.
I'm under contract with held for market.
Is it listing if they own the house? So
Yeah, comfortable.
Yeah.
But I think the answer is.
Oh, boy. So the power of attorney was valid at the time of signing it. Just as if it had been valid at the time I signed it. The power of attorney just has an issue of person, whatever, it is that person's signature. The question isn't really power of attorney, it's just the same thing as if I sign a list, I die. I don't think that here, I don't know if that contract survives.
The contract would survive, but you'd have to have somebody step in through the probate process to be able to go
Carry through. Okay, contract's still good.
She actually updated, she said, yes, EOA signed, but now there is a different executor.
The executor now steps in. Correct.
Yeah, there's a statute that says that the personal representative can continue with that purchase agreement, that it doesn't go away, that that person can just step in.
So I'm under the assumption that the listing agreement is a service agreement. If the person who signed the service agreement dies, then that contract is now no longer valid. But if the purchase agreement has been signed, then it is still valid, but it would go through probate or whatever the statute is to go down that sort of, that's the difference between purchase agreement and a service agreement. That's I'm not the lawyer, but that is my
Yeah.
understanding.
Again, part of this, in my
Yes.
ignorance, because not knowing what you guys have
Yes.
to care for clients.
Yes.
Yes, this sounds, I'm deferring to Tony a little bit because he's had more experience with probate itself. If the contract would have survived a death, the power of attorney signature would also survive death. So it sounds like.
Can I add a follow-up to that?
Yeah.
So the listing agreement that we have with a client, that's saying, I'm gonna represent you to sell this property. If they pass away, that listing agreement is null and void.
I believe that is the case.
I am also under that impression.
I'd be really curious. Sometimes the contract itself also says,
Not signed by power of attorney, but signed by the people and the people behind them.
yeah,
But if there's a purchase agreement that's signed and the people pass away, then it goes and it's part of probate and it still plays out.
it still plays out, still in the contract, still going to these sellers, but the executor is going to be the one that now is going to be signing the paperwork. So we got to get that person appointed.
But the executor completely exit them if they wanted to.
Only if the other person, only if it's mixable. So they're still bound in the same way with that. So specific performance or damages or whatever would be still apply, correct?
Only the executor of the estate that would be signing the paperwork for listing.
If so, if someone has died and the executor, the statute, by the way, calls it a personal representative, but I always say executor because it's what everybody calls it. So the question is the executor the only person who has to sign the listing agreement? The person that's already died, this person is now appointed, we're official, we did everything in the right order. Yes, it's just the executor that has to sign.
They have like 5 brothers or sisters.
Executor, the estate has now stepped in place, the person who has died. The executors, not up to you, the executors on the hook. So they will sign and you do what you do, and they are on the hook to the kids to do the right thing. But that's just the one. One of the reasons we really don't like to do co-executors and wills of trust, by the way, is now you've got multiple signatures. We try to do one at a time. You see that a lot. We won't want all 3 of our kids be in a trustee or a personal representative. Yeah.
Might be too vague, but if you have a trust, the home protected from unpaid nursing home bills.
Oh, good question. We get that a lot. No. The question is, so there's, if you're broke, that's what has to happen first. All of your assets have been used to pay for your long-term care. This is different than medical expenses. Long-term care, specifically long-term care expenses. There is the social safety net. If you don't have long-term care insurance, that will pick that up. But it's really a loan. So the state is going to pay for your long-term care costs. And then at death, the taxpayer wants their money back. And that's what you're talking about is the house safe from that? The house has some other statutory protections, but the trust itself will not protect that. And in fact, nothing protects from that. The only way to do it is there used to be a trust we could create in Minnesota up until 2003 that did allow you to put your stuff in this trust and have it protected from these liens. It's gone now. You have to give it away. You have to give your house away and then wait 5 years. That's
5 years.
Yep, 5-year look back. That is the way to do it in Minnesota at this point. If you get into that, there's a Supreme Court case that's supposed to have done that. And the state's ignoring it. It's weird.
Your house away, so you just sign up.
Sign a quick claim. Hope your kids are nice. You have all that problem with the capital gains, not getting to step up at death. You've got all this other stuff that you got to worry about, but at least it won't be subject. But this only happens. MA liens only happen once you've spent all your money, right? They don't start doing the liens until you're broke. So it depends on how much someone has and how much they will have and how much they want to. But yeah, trust. To answer your question, the trust will not protect.
All right, I think we have time for one more.
Good.
Do you recommend reviewing the trust with an attorney after it is done and an amount of time passes? In this case, one spouse is the other is living.
Okay, so when do we, a better question maybe is just like, or another way to phrase that is, when do we want to update our trust agreement? Number one, it's just super old. And again, I'll say 20 years, doesn't matter if you've had a lot in your mind, you probably don't think your life has changed. But I promise you, once I start reading through,
I'm still 25. What are you talking about?
think about your lives, just pause for a moment, close your eyes and look at yourself 5 years ago and think of all the things that have happened to your life in 5 years. That's going to happen again in the next 5 years and again and again and again. So it's old. That's a good reason that you probably don't talk to your executors anymore, because that's very, very common. Or if the parents and your parents are elderly, other than that, significant life changes. So significant changes in wealth, significant changes in relationships. We draft our documents so that if you have future children, they'll be incorporated. You won't accidentally disinherit people, but the grandkids start coming in. Divorce is a very good example, or death is a very good example. That is a very good reason to get it reviewed. And when I say get it reviewed, your most economical option is going to be to go back to the attorney that drafted it. So as much as we would like to work with folks, we oftentimes will just tell them, if we are going to truly review this thing and make sure it's statutes, we are going to need to spend some time on it. That could be expensive, or we're just going to repaper it, which might actually end up saving you some money. If they go to the attorney that drafted it, that's a familiar document. So if our clients come back to us, we know our notes, we know, and we can tell right away if it's a significant enough change. We suggest going back to the attorneys when possible. That said, yeah, significant life changes. That is a very good time to have it reviewed in whatever form that is. You guys are asking good questions. That was an easy hour. Thank you very much.
Very good.
Okay.
Yeah,
Good.
great.
Thank you. Well, we're at stonearchlaw.com. It's stonearch like the bridge, LAW.com. We have a lot of resources on there, a lot of videos, a lot of these 2-minute questions that people have. We have 100 videos of these types of things that people ask. So go check it out and certainly give us a shout. Any questions?
Thanks for sending those or bringing those handouts to you guys.
Yeah, I want a handout.
Grab one.
I'll put those there.
Sure.
Yeah, thanks again, you guys. That was fun.